Criminal defendants have a constitutional right to self-representation, but that right is not absolute, as explained in United States v. Kaczynski. The United States government indicted Theodore Kaczynski, the Unabomber, for mailing and planting bombs that killed and injured several people and gave notice of intent to seek the death penalty. When Kaczynski learned his attorneys planned to raise a mental impairment defense, he wrote letters to the judge expressing disagreement. The attorneys agreed not to present mental impairment evidence until the penalty phase. Kaczynski agreed to that compromise, and when the judge asked if he wanted to represent himself, he said no. During jury selection, Kaczynski's attorneys told potential jurors about his mental health issues, and he didn't express any concern. On the day the trial was set to begin, Kaczynski asked for a different attorney. The court denied his request and asked if Kaczynski wanted to represent himself. He answered no. The next day, he asked to represent himself, stating he couldn't accept the mental impairment strategy and was prepared to proceed to trial immediately. The court ordered a competency exam. After the psychiatrist found Kaczynski competent, the court denied his self-representation request, finding that it was made with the intent to delay the trial. The court also reasoned that because the prosecution planned to present considerable technical evidence and over 1,300 exhibits, it would be impossible for Kaczynski to take over his defense immediately. Kaczynski pleaded guilty in exchange for a life sentence. 1 year later, he moved to vacate the conviction, arguing his plea was involuntary because he was wrongfully denied the right to self-representation. The district court denied the motion, and Kaczynski appealed to the Ninth Circuit.